let's get started. Thank you for zooming in today with us. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, The Legal Brief with Barristan Law. For those who haven't been acquainted with me or the Sandbox, I'm Mackenzie, and the Sandbox Center is located downtown Barrie and online to connect people and their ideas to business resources on their journey to success. If you haven't attended one of our EIR sessions before, we're happy to have you with us, and for those returning, welcome back. Today, we're thrilled to have experts from Barristan Law join us to have a conversation around Canada's anti-spam legislation so that we can all feel a little bit more confident when it comes to sending marketing emails to potential clients and customers. Joining us today is Janice Bumberson, Senior Associate at Barristan Law, and Alexandra Paul, Article Student at Barristan Law as well, to discuss what you can do to protect your business and how these laws can affect your business if you're not aware. So before we get started, just wanted to let everyone know, please feel free to use the Q&A feature that's just at the bottom of your screen there. We'll be looking at those throughout the session and try to get to answering as many of your questions as possible towards the end. Thank you to all of our community partners for supporting with the sharing of our events. And of course, a huge thank you to our sponsor, Barristan Law, for delivering today's session. So without further ado, let's get it started. I'll hand it over to you, Janice and Alexandra.
Thanks so much, Mackenzie, and thank you for everyone for joining us this morning. As Mackenzie mentioned, we're going to be speaking a little bit about Canada's anti-spam legislation, sometimes referred to as CASL. So this piece of legislation came into effect on July 1st of 2014. So it has been in the Canadian laws for quite some time now, where we're coming up to its 7-year anniversary. But it is still a piece of legislation that we often get questions about, simply because it affects so many different businesses. In fact, it's meant to impact all businesses in Canada. It was introduced to limit or to try and eliminate unsolicited electronic messages that promote commercial activity. So on this first slide, you'll see that the entire intention of this legislation was to address unwanted electronic messages. So this includes things like text messages or email messages, where the intention of the message is to promote a specific commercial activity. So I know we all get our inboxes just filled with these types of messages from time to time, but now hopefully more often than not, those messages are from organizations that we have consented to reaching out to us or providing those electronic messages. So again, the intention here was just to limit hacking, malware, and spyware. So not just emails, but also things that require you to download different software programs in the background. Those are considered to be those unwanted electronic messages as well. Now, this legislation applies to any communication sent within Canada, or a communication sent from Canada elsewhere, or to a communication that's sent from a different country back into Canada. So it's a very broad piece of legislation, and Alexandra will talk later about how it's enforced, but that's the primary intention behind Canada's anti-spam legislation. Alex, can you flip to the next slide, please? So when we're talking about Canada's anti-spam legislation, there are certain types of exemptions that the laws do not apply to. So any messaging that does not encourage a commercial activity, for example. So if you're getting a message from somebody within a law firm, for example, that's simply reaching out and saying hello, or coworkers' emails where they're sending on funny jokes, things like that, Canada's anti-spam legislation does not apply to those types of messages. So similarly, messages within an organization between employees are not considered to be the messages that are impacted by CASL provisions. Political parties are also exempted from the CASL laws. And there are certain registered charities that are also allowed to send these kinds of messages when the purpose is for fundraising. Something to consider, though, is when we say charities, nonprofits that are not registered as charities would certainly still be impacted by these laws, as of course would any for-profit businesses. So when you're considering sending out a message, there are certain steps you need to take in order to ensure that you are not in violation of the CASL provisions. And we'll talk about those steps later on in our presentation. The other big exemption, of course, is that this law does not apply to communications from federal, provincial, or territorial governments. but it does apply to certain crown corporations, and that also includes municipal governments. So it's an interesting division there. Municipal governments must comply with CASL, and then provincial and federal and territorial governments do not need to comply with CASL for the purposes of communication. There's also at the bottom of the slide, you'll note that there's a note about partial exemptions. So this allows a business to send out one email initially just to see if people would be willing to receive future communications. So often if your email showed up on a sign-in list or something like that at an event that you went to, or if you're collecting people's email addresses at an event, you are allowed to send one email to them to see if they would like to sign up to receive future communications. And that is not a violation of Canada's anti-spam legislation. So as you can tell, this is a fairly broad piece of legislation meant to capture a high volume of communications. And it is interesting, if you log on to any of the government websites, you can see that the actual volume of unsolicited commercial electronic messages has decreased substantially since 2014. And that is in large part because of the enforcement mechanisms that are in place. I'm going to turn things over to Alexandra, who can talk about how CASL has been enforced historically.
So there are three government agencies that enforce CASL. The first one is the Competition Bureau of Canada, and they handle complaints about false or misleading representations and misleading digital marketing practices. The second is the Privacy Commissioner, and they handle complaints about electronic data collection and spyware. And then the Canadian Radio, Television and Telecommunications Commission, the CRTC, they handle complaints about sending unsolicited CEMs, alterations of data transmissions, software installations without consent. And these, during COVID, these agencies have seen a huge spike in unsolicited messages, malicious sites, alterations of data, software installations. And so there's been a lot of complaints during this time of COVID. And then we also have the consequences for violating CASL. So these are quite large and can be a little shocking to some people to see the fines that have been given out and can possibly be given out. So there are criminal charges. You can be personally liable. Board members can be held liable for the actions of their organizations and their employees. Officers and directors of a corporation can be held liable for wrongful acts of their corporation. And recipients of CEMs have the ability to bring private actions against the sender, and the damages are up to $1 million for an individual. You can make complaints about these messages, and consumers and businesses and organizations can report them if you're sent a message without consent. And to report them, you actually just go onto a website called fightspam.gc.ca, and they have a whole form where you can report. There's information that you have to input, and it's actually quite an easy process. Now, interestingly, these are some of the more recent violations and fines that have been given out. So between October 2019 and March 31st of 2020, there were over 165,000 complaints made to the Spam Reporting Center. So around just over 6,000 a week were made. And now, of those complaints that were made, the number one complaint made by Canadians was still the lack of consent. 44% were related to emails, and 30% were related to text messages that were sent without consent. So some of these fines that have been given out, so for example, Enterprise, which is down here, so they were fined by the Competition Bureau for sending emails that contained misleading promotions. So the prices in their emails that they said for a car rental were not actually the fees that you would be paying when you rented the car. Rogers, so Rogers Media was fined, and their fine was related to their unsubscribe mechanism. It wasn't working sometimes, and so people would unsubscribe to these messages and they would still be receiving them, and so they received quite a hefty fine. Now, another one is Porter Airlines, so up at the top here. Now, the interesting one with Porter is that they were fined under the CRTC, and they were a company that thought they were being compliant. They were under the mistaken impression that they were complying with the law, and they were just relying on general business practices and policies for proof of consent rather than actually storing the consent in the proper format. So they ended up being fined for lack of general information on how to stop receiving these messages, unclear unsubscribe mechanisms, lack of proper contact information, and they didn't maintain the unsubscribe grace period that all of this information Janice will be getting to in some other slides, but basically their website was confusing how to unsubscribe to their emails.
So thanks, Alex. So I think now we've shown how serious some of these fines can be under CASL, and if a company is found to be violating the provisions of CASL, so not only fines against the corporation, but also fines against some of the controlling minds of the corporation, whether it be CEOs or board members. So of course, many of you will be tuning in because you have businesses and you're hoping to ensure that you know how to comply with Canadian anti-spam legislation. So this next step lays out the three essential elements of complying with CASL. The first step is ensure you're getting consent from recipients. So we talked about that partial exemption under CASL that said you can reach out to individuals once to see if they would like to sign up to receive future electronic messages from you or from your business. And you want to get that express consent from recipients. So there's implied and there's express, two different types of consent. When you are getting this kinds of consent, effectively implied consent, someone sends you an email asking about your services. They don't necessarily say, feel free to reach back to me and provide me with information, but they've interacted with you or with some sort of form online or with a colleague of yours at a function and provided you with their business card, something like that, that indicates they want to hear from you. Express consent is really the easiest way and the best way to ensure that you are not going to be in violation of CASL provisions. And frankly, it's also the easiest way to defend yourself from an allegation of a violation, because this is where you would actually get written consent from someone. Either you've reached out to them or you've gotten them to select either in person or electronically a box that indicates they want to hear from you. So we've shown an example, and you'll see it on the next slide, but a really easy example of this is toggling. And I'm sure for most people who have a smartphone, whenever you've updated your software or if you've updated an app, there's oftentimes a screen that will pop up and say, do you want us to send you updates about future features or other related software? And sometimes it's a bit annoying. You actually have to select a box and then hit OK in order to allow it to finish downloading. That is what's called toggling. So that is where someone has physically had to do something to show that they want to receive future communications. So that's a good example of express consent. I should also mention another example of implied consent are recent customers. So where you have an ongoing business relationship with somebody and they've recently made a purchase, you are allowed, of course, to follow up with them to see if there's anything else that you can provide to them. So that is an important implied consent example. Now, the next step to ensuring that you're complying is to identify yourself as the sender. So it's important always, of course, when you're sending out communications to make sure that someone knows who is sending the communication. So Barriston LLP or Janice Mumberson would be what I would identify myself as, and also likely the purpose for that messaging. So this is obviously something that's really easy to do when you're talking about those legitimate business communications, because you are soliciting clients. So of course, you're putting your company's identity and your own front and center. You can understand, though, that currently there are many third-party corporations whose business it is to send out emails and communications on behalf of their clients. So when you have those middlemen, it's really important to make sure that if you're contracting with them, that they are ensuring all their communications identify your business as the one that the communication is being sent out for, and also identifying themselves as the sender. And that's just so people know who they're getting communications from. Lastly, and this was referred to when Alex was speaking about the recent fine that Rogers Communications received, that unsubscribe feature is so important. And I'm sure many of us have had the experience where we've checked the box or replied to the email with unsubscribe in the subject line, saying, please don't contact me in the future. And then the next week we receive another message, and the next week we receive another message. And so this unsubscribe feature is essential to ensuring that you're complying with CASL laws. So you want to make sure that if you say to unsubscribe, do this, one, that feature is working so that people are actually indicating that they want to unsubscribe from future communications, but also you want to ensure that it's working quite quickly. So you don't want people to still be receiving messages from you after 10 days. You want to make sure that they can quickly unsubscribe from future communications from your company. So on the next slide, we've just given an example of that toggling. And of course, so it's important to note that because the onus, if someone says that a company has violated CASL laws, the onus is on the sender or the business to show that they have actually complied, that they've actually received consent. And again, one of the easiest ways to do this is to get express consent, i.e. toggling, or something written with a checked box that says, yes, go ahead and communicate with me. Now, one of the elements of consent, of course, is that someone had to actively give their consent. So there's a right way and a wrong way of getting express consent, which is demonstrated on this slide, where we've outlined 3 different methods of toggling. So this is for an electronic kind of pop-up message, but another way would be to send that initial email saying, can we reach back out to you? You can't simply say, if we don't hear from you, we will assume that we have your consent. You have to say, please reply and let me know that I can continue to send you messaging. So on the left side of this slide with the big X above it, you'll see an example of toggling that would not pass that test when we're talking about, yes, we got express consent. This is a pop-up where it pops up, the box is already checked, and all the person has to do is hit proceed. So a person hasn't really turned their mind to whether they want to check that box to receive future emails. They've just hit that button to make that screen go away. They've just said, oh, I don't want to deal with this. I don't want to think about it. Let me proceed. So that is not a good example of express consent and would not help a sender show that they have express consent. The second box comes up nice and clearly with a little message that says you're about to purchase product A, and then below it is an unchecked option box that says that they want to receive the company Inc.'s newsletters. And so someone has to actively check the box. And the act of checking that box is their express consent. Finally, the third one is a really great example. So it's not just checking a box, you're entering an email address. So someone who wants to receive communications is actively saying, yes, I want to receive the communications. And not only that, they're providing the channel to which they would like to receive those communications. So it's express consent, it's active consent, and they've entered their email address and hit submit. Makes it really easy for the sender to show that they've received express consent to send future messages to that person. So those are 3 examples of toggling, I think laid out in kind of order of worst to best, and certainly either the second or the third would allow a sender to say to any of the enforcing bodies, yes, I received express consent to send commercial electronic messages to this individual. Other things like mailing lists. So if you have somebody go onto your own website and they enter in their email address, that of course is express consent. Or if you attend a live event and they write down their email addresses in a form that says, would you like to receive future messages from us? All of those are good examples of express consent. And then that paired with your unsubscribe feature should keep you safe from any allegations that you violated the CASL laws. So I think we've got a couple of questions that have come in. And I don't know, Alex, can you see those, or Mackenzie, are you able to see them?
Yeah, I'd be happy to start us off.
Perfect.
So the first question somebody's asking, can I send a CEM to a person who gives me their business card with an email address on it?
Sure. Alex, do you want to take that one?
Sure. Yes, you can. If someone gives you their business card, you are able to send them CEMs. I believe giving a business card is implied consent. Correct me if I'm wrong, Janice.
No, I think exactly it.
Yes. And so that's implied consent. So that only lasts for a certain amount of time. If they give you express consent to continue sending them messages after a certain amount of time, then you can send them that way.
Awesome. Does this legislation apply to spam sent from other countries?
So it certainly does. So CASL applies to all electronic messages that are basically moving within Canada. I think that's the easiest way to think about it. So whether the message originates in Canada and is sent out of Canada to a different destination, or whether it is sent from a different country into Canada, or sent even within Canada, the Canada anti-spam legislation applies to all three types of messages. So if someone's receiving unwanted commercial electronic messages from a different country or a company located outside of Canada, they can still go to that, I think it's an awesome name, the fightspam.gc.ca website, and they can make a complaint. And I think that's why there are so many bodies that are responsible for enforcement, is because there's so many different forms of electronic messages and commercial electronic messages. So they do have different bodies that function at different levels of government. And certainly they will inspect those kinds of electronic messages coming from outside of Canada.
And Ancestry.com was actually a good example of that. It's an Irish company, and they have no employees in Canada, no offices in Canada, and they were sanctioned under CASL for their messages they sent.
Wow, that's so interesting. And I find that every time, a spam email comes across my inbox, I report it as spam, but I'm never going to think to go and report it to the government website. So I'm sure there's so much more that is out there than even the numbers that are reported, because of people not, obviously wanting to just take the next step to quickly go and report it. But I could only imagine.
I think you're absolutely right, Mackenzie. I don't know about anyone else. About 2 weeks, well, maybe 3 weeks ago, I started to get quite a few unsolicited text messages, and they weren't from telephone numbers. They were from email addresses that were 20 characters long, complete gibberish. Mm-hmm. And happily, my cell phone allows me just to block that sender. Unfortunately, for these types of companies, they've got 20 other burned email addresses that they send messages from. So the amount of effort it takes to log something into that fightspam.gc.ca website, probably not worth my time and effort, unless it gets to the point where I just can't take it anymore. But I think you're likely right. There's a huge volume that's still unreported.
Mm-hmm. Mm-hmm. The next question, somebody's asking, if I'm on social networking sites such as LinkedIn, Twitter, and Facebook, is it considered express consent when people like or follow my page? Can I send messages to my fans through the social platform or through email, or both?
This is a great question, and I think the answer is it will depend. So I think we've all been in the position where we've received sort of unsolicited messages directly to our social media inboxes. And I rather think that the first few would sort of fall under that partial exemption, where they're reaching out to see if you're willing to receive communications. So I think in terms of following a page, I don't think that's an unwanted commercial electronic message or request to follow a page. In terms of repeated efforts to engage you in messaging, I think eventually, if there is that underlying commercial purpose, I think that would be found to be a violation. Alex, do you have anything to add to that?
Yeah, so I think that with this legislation, just commenting on someone's post wouldn't necessarily apply to this legislation. But when it's a direct message from a sender to your inbox, say your inbox on Instagram, it could fall under the umbrella of the CASL legislation.
Okay, cool. Yeah, I never really thought about it in that way. So it's an awesome question. If I'm a non-for-profit, are there special regulations for me since I'm not selling anything?
This is such a great question. And so I talked a little bit about the differences between registered charities and nonprofits at the outset. So if you're a registered charity and the intention of your message is to fundraise, then you are exempt from CASL. but CASL does apply to nonprofits. So it really does come down to the nature of the messaging from the nonprofit. So if you are a nonprofit, I would still strongly recommend trying to get that consent, either implied or express, before you're sending out commercial electronic messages. And again, it's commercial electronic messages. So while you're not trying to sell something, it's if there's still an underlying purpose there to sort of engage in commercial activity, you could still fall under that umbrella. So I think it's message specific, and I think to be safe, you want that express or implied consent, because even if someone starts out, if it's just like it's a happy holidays message or something you send, and they engage with that, that's not a commercial electronic message. But then when you start to follow up, if they haven't actually consented to those ongoing messages, and you don't have an unsubscribe feature, I think you could find yourself in some hot water.
Perfect. If I already have an existing contact list, do I have to reconfirm consent if I've been mailing to my contacts for years? How does grandfathering work?
Oh, so in terms of grandfathering, I don't think that's really applicable, because as Alex mentioned, and she can weigh in on this a little bit more, it times out after a while. So if you're going to be continuing to email your contacts, always have that unsubscribe feature. And I think it is a good idea to sort of send a message every once in a while, just to remind people, hey, you can unsubscribe, or we're reaching out again to get your consent to continue on. Alex, did you come across the actual, and I'm sorry, my memory's failing me, the actual time period in which their consent sort of lasts?
I believe for implied consent, it is 6 months.
That sounds right to me, but we can confirm that for anyone who knows.
Yeah. Express consent, if you received it in the proper way back in the day when you were giving consent from whoever your client is that you're emailing, if it still will fall under how you need to get express consent now under this legislation, you'll be grandfathered in that way because you're still complying. But I believe that you still, no matter how long you've had this contact list, you need to get the proper consent.
And I think the key thing there too is just always making sure that unsubscribe feature is available, especially where people had basically given express consent. Their consent still lasts, but if there's no mechanism by which they can withdraw that consent, it's no longer consent.
Right. Okay, perfect. Thank you. Somebody's asking if I want to send a CEM to an email address that's published in plain sight on a website, do I have implied consent under CASL?
This is a great question also. So my interpretation, and Alex, you can correct me if you've got a different perspective on this. I think this would be very similar to sort of exchanging a business card, in the sense that I think it's implied consent, unless it's specifically inviting, of course, commercial electronic messaging for a specific purpose. I think that's still implied consent, even if you're sending about something that's completely unrelated to that purpose. But again, I do think it's, if they say no after the first communication, which is that partial exemption, I think you have to cease and desist. You can't just add them to your ongoing contact list.
Yeah, and an important part about this too is if someone just has their email address on their website, if they specifically say somewhere around that email address that they will not be, that you can't send them unsolicited messages and CEMs, then you are not allowed to. That is their express way of saying you are not, that's their unsubscribe mechanism to posting their email address online, basically.
Okay, perfect. If I'm using a third party to conduct my email marketing, am I still potentially liable?
Yes. So this is becoming more and more common. And so I think one of the biggest things about this is identifying the sender. So that's a requirement under Canada's anti-spam legislation. So I think anytime that you're working with a third party, you want to make sure that they're specifically stating that they are sending the message on your behalf. And then when you are contracting with them, you want to make sure that you are making it a requirement that they have gotten the consent from the recipients of the messages, because it's an argument like, oh, I didn't know that they were sending these unwanted commercial electronic messages to everybody. But all the while, that's really what you were hoping, was that they would have this huge mailing list and would just blast out this communication. So those companies that scout the services of third-party senders, that's not a way around the laws. That's not a way to offset or kind of get away from potential liability. If the message is being sent out on your behalf, you are potentially liable. So it behooves you to write into a contract that third-party sender is going to comply with CASL law.
Okay. Yeah, somebody else is asking a similar question. Basically, if they use a service such as MailChimp, are they responsible for maintaining a consent list, or must they maintain a list as well?
So I think that's a really great question as well. So again, if you are the person who is receiving the allegation, you want to be able to show that you received that express or complied consent. So whether you want to be actively updating that list, or whether you want to have some sort of indemnification provision in your contract with MailChimp that says that they will actively maintain that consent list and that they'll make it available to you at all times or upon request, I think that's important. But at the end of the day, if MailChimp is violating the laws and they can't show you that active consent list, it might be too little too late. So you want to make sure that you always have access to that express consent list, and that you've got some sort of contractual provision that says they will only ever send it to those that they have implied or express consent from, that they'll provide that unsubscribed feature, and that they'll make that list available to you on an ongoing basis. And I don't know if MailChimp would ever agree to do this, but potentially indemnify the sending corporation if they violate the terms of their contractual agreement. And that way, at least you could sue for damages, but no one ever wants to be in that position. So I think sort of the ounce of prevention is worth the pound of cure in this case. Make sure they are maintaining this list and that you have access to them so you can show your defense if ever there's an alleged violation.
For sure. Perfect. Thank you. Somebody's asking, does CASL apply to electronic messages sent in relation to surveys or market research?
Oh, I love this question. So again, the underlying purpose is always that there's a commercial purpose to it. It's a commercial electronic message. So I would argue that yes, if there is somebody who's making money and they don't fit under the exempt class of senders, the charities, the federal, the provincial governments, the political parties, if it's a company that this is their business, then I would say yes. Alex, are you aware of any exemptions for these kinds of activities?
No, I'm not aware of any. I think that if it's so fact dependent, it really depends on what you're sending.
And I think too, like we touched on the fact that it doesn't cover emails between coworkers. It doesn't cover communications with implied consent where it's a recent customer who's made a purchase. And so a survey comes in and says, how did we do? So I think you're right, Alex. It's going to depend on those facts. But I suspect that if there's a company out there who makes money for collecting marketing data and they send an electronic communication, and again, it's probably one of those preponderance of the facts sort of things where there's no unsubscribe and they send repeated emails, I think very quickly they would find themselves in hot water. But if it's one communication to do a survey and that's really it, they might get away with it. I'm not sure, but certainly I think implied consent would be the best way forward. Maybe they're going to get under that partial exemption where they're going to send out one email that says, we'd love for you to do this survey, and if you sign up here, we'll send you more surveys in the future. But if you're repeatedly getting them and there's no way to unsubscribe from them, that's a violation.
That's good to know. Somebody's asking, if I send messages to recruit individuals for employment opportunities, are these messages subject to the requirements of CASL?
That's a good question.
Yeah.
I think it depends, basically. Janice, I'll let you take this one though.
Yeah, sure. And feel free to weigh in. So I think it depends on where they got your email address from a little bit. So on websites like LinkedIn, we talked about a little bit about social media, but I think in particularly on LinkedIn, the participation in a website could be considered implied consent, especially if in your profile you've said seeking job opportunities or always interested in networking. Sort of the opposite of the example Alex gave, where someone puts right near their email address, do not send unsolicited messages. I think by participating in certain types of social media platforms, there could be implied consent there, or even express if it's right in the profile. If someone reaches out to you directly through a work email, and again, they don't stop when you ask them to stop, then I think it's certainly a violation. I think if it's a one-time thing, it's a little bit different. So I think it's always running it through that fact machine, that kind of factual matrix, and saying, well, is it a one-time? Have I signed up or in any way held myself out to be open to these communications? Am I able to withdraw consent, and are they respecting it when I withdraw that consent? I think a one-off email, probably not going to be a violation, but again, repeated efforts and repeated attempts without your consent would be, they'd likely find themselves in hot water. I think there's likely enough there to meet the definition of commercial electronic messaging. Most people who are reaching out would either be recruiters or corporations who are hoping to make a bit of a profit from that kind of employment relationship. So I suspect that they would meet the CEM. Alex, do you have anything else to add to that?
It would also apply if you are signed up for one of those websites like Indeed, and you've signed up to receive messages from potential employers. You're safe in that regard, and you're one of the employers on Indeed, kind of doing your search of the people that are signed up for it, then that would definitely be okay.
And that's actually a great example you gave, Alex, because it's almost the reverse situation that we were talking about previously, where people are soliciting the services of third-party senders. In this case, employers are soliciting the services of a middleman to collect consent from individuals looking to hear from employers. So again, it's that key component, that consent. And so in any manner that it's expressed, if it's consent for a particular subject matter or consent to a particular sender, that's always going to be really crucial to maintaining that compliance with CASL.
That's perfect. That's so good to know. It's a great question.
Yeah.
The next question, somebody is asking, as an individual, is there recourse against businesses operating outside of Canada, i.e. e-commerce shop based out of Florida, you've made a purchase from, you receive your goods, and a few months later you hit unsubscribe, but then the marketing emails keep coming. Sometimes, in fact, suddenly you're receiving emails from what appears to be a subsidiary from the same company, but coming from a new different email. So what recourse does an individual have in this regard?
It's so frustrating when you receive those kinds of emails, and these are exactly the kinds of communications, especially the ones coming from that subsidiary after you've hit unsubscribe. That's when you go to that fightspam.gc.ca website, and obviously it's frustrating because then that process is out of your own hands. But as an individual, you can respond, although perhaps the person asking this question already has, and say, I've reported you to our federal government because you are in violation of the Canada's anti-spam legislation. And just say, one more time, I'm asking you to remove me from this list and any list within your larger organization. Because certainly if there was implied consent for that initial sort of parent corp, but the subsequent follow-ups from the subsidiaries are already sort of stretching the limitations of compliance. And because it's just, as we said, any communication coming into Canada is subject to Canada anti-spam legislation. So just because they're from Florida doesn't mean anything. You can still go ahead and report them to the fightspam.gca.ca website.
Perfect. I just put it in the chat there for everyone as well if they want to take the time to go to the website. Is there a particular type of unsubscribe mechanism that should be used that you guys could?
So typically the bottom of your email, it'll say unsubscribe here to messages. That's great. And if there are subsidiaries or other email addresses that could potentially be sending you CEMs, you should have an option to unsubscribe all or to unsubscribe from particular branches of that company. If, say, you don't want to receive, I can only think of e-commerce websites now, if you don't want to receive certain types of, if you only want to receive emails about their sales, or you don't want to receive certain types of messages, sometimes the individual workers will send you messages. If you've purchased from them before, you should be able to unsubscribe just from their emails and that kind of thing.
And I think really the best unsubscribe service is the one that tells the sender right away, or maybe even automates the deletion of that email, because your unsubscribe feature, if you're not following up and actively deleting those recipients, it's not doing you any good. So certainly there are services that help you administer that unsubscribe service. So I think you upload your sending list, and they will help you manage it. So when someone hits unsubscribe, you may get a message or you may get nothing. It may just delete that email address from your list. Mm-hmm. But as long as it's clear and easy to find for the recipient of the message, an unsubscribe mechanism works. If it makes them go through 5 or 6 steps, you might still find that that's not enough. You might need to make it easier, but certainly kind of a click or a response to unsubscribe in the subject line would certainly work well.
Perfect. I think this question here is a follow-up to the previous one about e-commerce, but as an organization, what rights do you have / where's the line drawn from a retargeting, remarketing standpoint? So using the previous example for like a Florida e-commerce company, I am now, my customer purchased 3 items from 3 separate departments of my e-commerce platform. Do I have the right to put that customer on 3 separate targeted email lists or one from each department? Do you guys have any insight on this?
So I think this is very similar to what Alex was speaking about in terms of the unsubscribe feature and being able to unsubscribe from multiple different lists. So if you're not sharing one centralized list that someone can unsubscribe from, there's a few things here that I think you want to consider. One, if they're actually separate legal entities versus departments, then they all got consent initially, but when someone hits unsubscribe from one entity's list, they're off that list. I think from a customer service perspective, it makes sense to say that you're also on these 2 other related entity lists, especially if it's coming from a similar sender email. But if you've got implied consent on those other 2 lists, you can still send those emails because you still have that implied consent. But be ready to field the frustrated telephone calls from the customer who thinks that by unsubscribing from one, they've gotten rid of all 3. If you're not 3 separate legal entities, if it's one corporate entity that just happened to have three different product types, for example, then that entity, there was the withdrawal of express consent that was targeted towards that entity. So I think that's sort of something to keep in mind, just from a legal structure perspective, the difference between 3 corporations versus one corporation with 3 mailing lists.
Perfect. If my business violated CASL, can I be personally liable?
Yes. Alex, were there any examples? I know that recently there was a CEO that was fined, I want to say $100,000 personally. I can't remember which corporation it was, but Alex, did you have any examples of personal liability from your slide 7?
I'm trying to remember when I was going through them. There were personal liabilities for a few of them. I can't remember any off the top of my head, but you are absolutely personally liable for messages sent out by your corporation.
And I think Alex had mentioned it's not just sort of the CEO, it's also board members. Yeah. So it's always going to be factual. It's about, the controlling minds and things like that with the corporation. But there are absolutely fines that will attach to individuals at those corporations because the government is taking it quite seriously and trying to limit the amount. And that's why it's up to $1 million for individuals, $10 million per corporation per violation. So that is important to keep in mind.
Mm-hmm, very important. Next question here. This may have already been asked. If I'm doing a raffle at an event, where to enter, you must drop a business card in a bowl, and there is a sign next to the bowl saying, by dropping your business card, you are allowing marketing emails to be sent to you. Is that expressed consent?
So I'll take a stab and then I'll defer to Alex. I wouldn't think that this is express consent. I think it's implied consent. So I do think it has that kind of moonlight clause. So I do think that after an event, and remember, it's all about what's the worst that could happen to your company versus the worst that happens to that individual. The worst that happens to them is they get a little angry, they get a couple of communications that they don't want, the worst that happens to your corporation is you get a hefty fine. So I don't think it's express consent. I think the appropriate thing to do in that case would be to send an initial email out just to the people who drop their business cards saying, you recently put in your business card. We're reaching out. We hope you enjoyed the presentation. We'd like to add you to our mailing list. Right. And I think at that point you could say, if you do not wish to be part of that, then please click below to unsubscribe. And I think this is very similar to the case of exchanging business cards with that sort of six month, which we will confirm, sort of sundown clause. Alex, would you agree, or do you think there's an exemption?
I would agree. I just think that you're always better safe than sorry. If someone did report you for sending these emails, it's just not something you want to face. You're better to maybe shorten your email list by a couple names if they don't consent than be facing the fines.
Absolutely. Those are great solutions. Thank you. Next, somebody's asking, as an organization, what rights do you have / where is the line drawn? Oh, somebody actually already asked this question, so it's a double. Never mind. Next. With LinkedIn specifically, if you send or receive messages from people in your network, would the connection of being in your network provide consent? They can unconnect at any time in LinkedIn.
I love this question because I think it really highlights the shift in the business networking that we've seen in the last decade. So previously, for example, if you went out for lunch with somebody and then you followed up with emails, there would be no question that you're fine. You're not violating CASL. But now with LinkedIn, it's an active networking site. So of course you can unconnect from the person. So if they haven't disconnected from you and they haven't sent you a message saying, please stop, then I think you're okay. If they send you a message that says, please stop, and you're worried because you're just blasting the whole list, I might disconnect from them or remove them from your list just to be safe. But you're right. They have the ability to disconnect from you so they're not receiving your messages. Even if they're just not responding, if they're actively on LinkedIn, they don't have anything that says, do not send me opportunities or anything like that, I think you're okay to send out those messages.
Right. And I mean, I know I've gotten multiple messages across from LinkedIn, but I'm not going to obviously go and report them right away. So it's good to know.
And I think too, I know that LinkedIn themselves often send messages saying, hey, upgrade your account. But typically, if you're reading any of these social media platform kind of terms and conditions, you're messages from them within that platform. So that's important to note too. So messages from LinkedIn, definitely it's in their terms and conditions. They're not going to be stepping outside CASL. But in terms of messages from recruiters or possible employees or employers, I think you just need to be mindful that if they withdraw consent or demonstrate that they do not want to receive those messages, that you need to take active steps to ensure you're not violating CASL.
Definitely. So we have one last question here. If anybody has any other questions, feel free to throw them in the chat. We have about 10 minutes left, but we'll get to this one here. I've seen unsubscribe features that say things like, please be aware of this, may take up to 2 weeks. Is there a limitation to how long it can be listed to take to unsubscribe somebody?
I believe it's 10 days to get someone off your list. So you may receive a couple other emails in the meantime, but there's a 10-day limitation.
And the government actually tracks that. That's one of the stats that you can see on the Fight Spam website. They actually break down the nature of the complaint. And so often that is the main complaint. I unsubscribed, but I received a communication more than 10 days later. So that's why when we were talking about that unsubscribe feature, the best mechanism is the one that lets you update your list really quickly, because that's 10 days can come and go pretty quick.